I'm going to talk for a bit about assessing a situation for trial. As you can see, I've done a little bit of artwork to help guide my topics. Up here at the top, you see a color-coded spectrum. This is about outcomes, the range of likely or potential outcomes for your situation. On the far left, you've got your worst case scenario, your bad outcome from trial. Over on the right, you have your best case scenario. What's the best thing that could happen from trial? Now, this spectrum is influenced by things beyond your control. One thing that affects outcomes is the law. The limits over here on the far right and the far left are the constraints of the law. What can the judge do? What can the jury do? And then how are they limited? What can they not do for you? For example, in a criminal case, a jury cannot get you probation. In a family law case, your divorce judge cannot change the other side, cannot change their attitudes, cannot change the way your spouse or ex-spouse treats you and your kids. So there are limits. Other things that affect outcomes are the behavior of the judge. If you get bad pretrial rulings from the judge, adverse, this is not going well, you have to assess your judge's attitude toward your case as you're getting ready for trial. Am I likely to have problems with my evidence because of the way the judge is treating my case and my situation? The other side can affect your assessment of outcomes. The behavior of the parties in settlement negotiations. If the other side is very unreasonable, that can affect how you're assessing this. I'm going to talk about that a little bit more here. So you can affect this too by your behavior and putting yourself in a position to where you either have a lot or a little bit to lose. The other side can do this too. If the other side is completely unreasonable, and in settlement negotiations, they won't move past yellow here. And you're assessing the facts that you know, the things that you know about your case, and you think, I could land somewhere here in red, but I'm also really likely, based on my facts, to get over here in green and maybe even get into the blue. Then you may say, hey, I'm going to have a better shot at trial than the other side is giving me credit for. On the flip side, though, if the other side is making you a good settlement offer, or if there are factors about their settlement offer that make you think, hey, I've got risk here. Their settlement offer is here in the range of yellow and green, but if we go to trial, it's all on the table for us, then you really need to think about risk and reward. Is trial going to be a lot better for you than settling the case with some parts that you don't really love, but in a way where you can tolerate the outcome versus the risk of trial? Because there are unknowns and uncertainty in trial. Trial means that someone else, a judge or a jury, is making a decision about your life, and settlement is about controlling as much of those terms as possible. You don't have complete control, but in settlement, parties can agree to outcomes that a judge or jury can't do. For example, in a criminal case, negotiation with the prosecutor can lead to probation that a jury can't do. In a divorce case, you can reach agreements about things like paying for private school, things that a judge is not allowed to order, paying for college. All those things are on the table, whereas if you go to trial, the judge is just going to have their hands tied. So I want to talk a little bit about how you can put yourself in a good position and kind of mitigate your risk for trial. And that is in settlement negotiations and in trial preparation. You want to identify what is the most tolerable bad outcome that you can live with and really push yourself as far as you can in settlement negotiation. And what you're trying to do is put yourself in a position to where if the other side is not doing the same kind of assessment as you, that you have less to lose in trial. Yeah, you may go to trial and something bad may happen. You've got to recognize there are unknowns here. You may go to trial and land somewhere over here further to the left, but you're really trying to mitigate that by putting the other side in a position where they have something to lose too. If you're moving over into the yellow territory here and the other side just wants it all, they're only going to tolerate something on their far right, then you can put them in a position where they have a lot to lose. Sometimes that's just a psychological shift where you've made a settlement offer that just pains you, but it will end the case if the other side accepts it. And they're unreasonable, then you go to trial. There's a psychological shift where they know they left money on the table. They have something to lose, even if they have good facts. You made them an offer to where they're risking not getting that at trial. So you can shift the dynamic a little bit just through some strategy and by pushing yourself as far as you can tolerate by trying to resolve your situation. And that's different in different cases. In a criminal case, can you tolerate some jail time? If you go and you lose, you may go to prison. Versus a settlement offer, a plea negotiation where you would have a little bit of end time, or you're going to get a suspended sentence versus a deferred. These are all things you want to talk to your lawyer about your risk tolerance and about what are the potential outcomes at trial. What are our facts like? What are our witnesses going to say? What does this mean for my situation? What kind of judge am I dealing with? Those things are all relevant and important things to think about when you're thinking about your strategy and what is my risk tolerance for my case. All right, so now I want to talk about the circle down here. And this is just another way to look at and think about how you're going to make a decision for your case. This is about human decision making. This is about the information that we have when we're thinking about going to trial. Some of this is based off Dr. Daniel Kahneman's work, Thinking Fast and Slow. I recommend that book for anyone because it talks about human judgment and decision making. It's based on decades of psychological research. And what the doctors found, what these psychologists found in these studies is that as human beings, we are pretty terrible decision makers. And to make things even worse, we think we're good at it. So we've got this compound effect of we're not good at making decisions, but we think we are, and we're unaware of how bad we are. And I'm going to kind of demonstrate that here visually. Here in this little part of a pie chart, we've got what I call known knowns. These are our facts for trial. This is what we know we know. Not all these are good. These are the bad facts that we know about our case too. This is how we're going to assess our case and our risk tolerance and really govern a lot of our decisions getting ready for trial. Right next to it over here, we have our known unknowns. These are the factors that we know about. We know these are factors for our situation, but we don't have answers for them. We have question marks here. What are these? We don't know these. We're kind of incorporating this into our risk assessment. We know these are factors, but we don't know what the answers are. Now, here's the problem. Everything else in this pie chart are what we call unknown unknowns. This is the universe of things that we don't even know that we don't know. And I'm going to give you some examples. 10 months ago, we have no idea that there's going to be a pandemic that shuts down the country and our courthouses. And we have no way of knowing that. From the movie The Rainmaker, based off John Grisham's book, we've got a judge that's making bad decisions for our case, and then he dies. Less extreme than that, in Tulsa County, every once in a while the district judges decide to shake things up. You could have a trial set, be ready for trial, feel good about it, have trial in 30 days, and then the district judges shake up all the special judges, and you have a new judge assigned to your case with a whole new calendar. Now your trial date's gone, and you've got a judge, and you have no idea how they're going to rule in your case. Other examples of unknown unknowns. You could go to trial, you could be assessing your parenting and custody situation, and you don't know that the other side is secretly planning a trip or a relocation to move their job and to try to move your kids across the country. It happens all the time, and it happens all the time after a divorce when it was never discussed or even thought about during the divorce process. So we make all these assumptions and we think we know the factors, but there's this whole universe of other things, things that are knowable, but we don't know that we don't know them. And then there are things that are unknowable, and we will never know that we don't know these factors that we really wish that we knew because they would be important for our case. So, what we end up doing here when we're working on a case and getting ready for trial, all we're trying to do is move this line right here. We're trying to move it. We're trying to move this line a little bit more and make some of these known unknowns. We're going to move them over and make them known knowns. So we do that through the discovery process, through an investigation, through depositions. We know we don't know these things. So we ask the other side and we ask witnesses and we try to verify it. Here's the problem. So we're moving these, right? And so we have a little bit more known knowns. We're thinking about trial. We're not thinking about our unknown unknowns, and that's just a major problem with every human decision. But also, our known knowns, a lot of times, we're wrong. Things change. Witnesses change their story. Facts change. People make mistakes. Judges make mistakes. You've got a whole other realm of human error. So your assessment is just a fraction of the things that you wish you would have known. And it's prone to error. So the purpose of this video is just to show a cautionary tale whenever you're feeling too good about your case or even when you're feeling too bad. There are things beyond your control that are affecting your situation. And there are things that you don't know that are going to affect your situation. So you really don't need to overestimate or underestimate your case. You really need to assess your risk tolerance and think about what are the potential range. Talk to your lawyer. Work on your case. Look at your facts. What is my range? What's my worst case scenario? Can I live with that? And if I can't, what in the world can I do to mitigate that, to take my worst case scenario off the table and to try to move over here as far to the right as possible? How can I get my case here? Can I do it through a settlement? Can I do it through kind of pushing myself and testing myself and making an offer that goes over here? I've heard some great lawyers talk about this area, this range here in the middle that moves over toward the left as the zone of pain. That's the outcome that I don't really love, but I can live with it, and I'm not getting my worst case scenario.